I don't understand why Fox's knowledge or lack of knowledge really has anything to do with the question whether what comes out on the air is indecent or profane. It may have a lot to do with whether a penalty should be imposed, which was not imposed in this case. But you would agree, I take it, that planned or unplanned has nothing to do with whether the content is indecent.
Right. I think if it's scripted and intended to be put forward on the air, there's still the fundamental question as to whether or not the particular words can be declared to be indecent. And then after that, obviously, you go into the question of intent.
Or if they're integral to the work, then they may be found not indecent, like Saving Private Ryan.
Right. There's no question that the Commission has a basic approach that says that we will presume that the use of these particular expletives and or specific words is presumptively indecent, and then you have the opportunity to come in and try to rebut that presumption by saying that there is some contextual basis for supporting it. But, you know, obviously the creation of the presumption in the first instance is a complete departure from any notion of context, because it's saying these are words that are categorically barred, which is something the Commission has never said in 30 years of enforcement of indecency.
Well, the words are the same. The regulation is the same that's been in effect, hasn't it? It's just, it's a different level of enforcement.
It's a demonstrably different level. And
it's not new words. They always, and these are the words that have been used in other contexts as well. It's the barring of the reference to sexual and excretory activities and organs.
Well, the generic policy has been essentially unchanged since Pacifica was decided in 1978. But yes, you're right, Your Honor. What has changed dramatically is the Commission's decision that any use of these particular words becomes essentially a per se violation, regardless of the context, which is, as I say, a dramatic departure from anything that existed prior to this.
An agency that changed how they view words that pre-existed, and they started by 2001 giving industry guidance, which didn't change.
Didn't change a thing on this score, no, Your Honor.
And then in 2004 issued the Golden Globes order. Do you argue before us that they didn't give reasoned analysis for the change?
Yes, that is precisely what we're arguing, Your Honor. That if you look at the justification for the change, all that's put in place is this first bite principle. That's essentially their argument, which is that you have to stop any kind of exposure to these words for children. And
what would they have had to do to convince you that it was a reasoned analysis?
Well,
would they tell you that children were harmed if such studies exist?
That would certainly, yeah. I mean, I think it would be very difficult to demonstrate that exposure to a single word could remotely injure children. But
well, for children who live in bubbles, it would be fine. But if they live in the world, your argument might be more persuasive. But if you can keep the child away from every form of communication, then
that's fine. And if the Commission can identify any child in that category who is nevertheless watching broadcast television, that would be quite an extraordinary achievement. But it's a burden that seems to me that
there wasn't reasoned analysis, or that there wasn't sufficient proof and evidence to support the reasoned analysis?
It's both, actually. I don't think there is a reasoned analysis embedded in here.
Is that something that, in your view, could simply be plugged up by setting forth some more extensive analysis, or is it your position that the position taken by the Commission is simply unjustifiable, so that there can't be any reasoned analysis of something that's unjustifiable?
I mean, our alternative argument, obviously, is that this is First Amendment protected activity, and that you need to have a compelling state interest and narrow tailoring, and you're not going to get that in this context.
I've been puzzled by your argument about lack of reasoned analysis. It seems to me that they explain why they take the position that they take.
They do, but I don't think it's reasoned, Judge LaValle. I think the problem with that is their argument is that you have to prevent children from any exposure to these particular words, and then they proceed in the same breath to recognize that exposure to these particular words is routinely permitted at these particular times if it can be justified on alternative grounds. Either there is a huge, compelling, overriding interest.
Now is more along the lines of that there can be no reasoned analysis of something that's inherently unreasonable.
I think that, yeah, at the end of the day, that is our argument. But you don't have to get to that point, I don't think, if you want to simply say the Commission hasn't come up with an adequate justification for a 180-degree reversal of its precedent. If it wants to go back and try again, I suppose that's fine.
So what would be an adequate justification to get back to what I think was Judge LaValle's original question?
Well, in the context of a single use of an expletive, I don't know that there's ever going to be anything that satisfies that.
So the bottom line of your argument here then, Mr. Phillips, is that the FCC cannot regulate the fleeting expletive, if you will.
I think that's right, although I don't have to sustain that argument. All I have to demonstrate is they haven't done it to date. If they want to go back and try to do it, that's fine.
But in both of these cases, the Fox Television Network broadcast the F word on primetime television. In neither case does Fox make any effort to defend or to justify the use of that language. So the only issue here is that raised by the conceitedly gratuitous use of the F word on an entertainment awards show when children are in the audience. The Federal Communications Commission...
Why isn't this just a sort of... I mean, taking your point of view, which I'm not necessarily sure I agree with, why isn't this just the sort of Damocles hanging over the head of every broadcast station around?
I mean, because the only thing that the Commission has decided in this case is that
in those circumstances, the use of those words, which Mr. Miller has recited for us several times, is inappropriate and is subject to fine.
Right.
That's where you want to leave it. Well, let me give you a hypothetical, Mr. Miller. This is being fed out by cable here, and presumably the broadcast media can pick it up. And let's say they pick up the portion of Mr. Miller's argument, or, excuse me, Mr. Phillips' argument. I'm sorry, thank you. And I won't repeat your brief since we have the words in the record here, but the use of the words are actually broadcast over 6 o'clock news tonight. Is that going to be subject to FCC hand slapping?
I think plainly not, for the reasons stated in this very order with respect to the early showcase. The Commission has emphasized that it will exercise great restraint when it comes to news programs.
All right, well, let me...
There's no news exception. You say there's no news exception.
There isn't a news exception in the sense that you can't simply slap the label news on any broadcast and immunize it.
Let me give you the hypothetical, expand the hypothetical where Fox, wanting to air so its viewers are reminded of exactly what's at issue here, pulls up the clips from the Billboard Music Awards and shows those two instances of Cher and Nicole Richie as background or in conjunction with reporting on what's happening in this courtroom here today.
I mean, to be indecent, the use of the language has to be patently offensive, which under the Commission's analysis requires that it be presented.
So how is a rebroadcast of the clip in the context of news any less offensive than it is in the Billboard Awards?
Because in that context, as the Commission explained in the early show order, it's not being presented to pander or to titillate or for shock value. It's being presented to inform viewers of what the case is about.
Can I talk about the early show for a second? Because you just said that you can't slap the word news on anything. Okay, so this is what you found merited a news exception. It was a discussion of a reality show, correct?
Yeah, that's
now,
right.
That's not real in the sense of being real. It's an entertainment show, correct?
That's right.
And the exception that the FCC found for news was someone who had, as I understand it, been made to exit from that show, talking about people who were still left on that show. And you call that news?
The Commission,
just asking.
Yes. The Commission is not...
What wouldn't be news under that standard?
Well, I mean, the Commission is not in the business of second-guessing the journalistic and editorial judgments of broadcasters. The early show is...
So why can't they call everything news? You just said you can't slap news on anything, and now you're saying you're not in the habit of second-guessing. Which is it?
The test that the Commission articulated in the early show order is that we said we would defer to CBS's plausible characterization of the program as a news show.
Did you mean to suggest by the use of the word plausible that it was a stretch?
Not necessarily. I think that word is just in there to emphasize that it is indeed a very broad exception. But questions of the breadth of the news exception are not implicated here, where there is concededly no journalistic theory on which Nicole Richie's
announcement
language.
of important music awards somehow journalism?
One could perhaps argue that, but Fox has not made that argument. It didn't say that before the Commission. It hasn't said that in this court. At every stage of this case, it has made no effort to defend the language that was used by Ms. Ritchie or by Cher the year before.